Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Ooley, and this is episode 150 of the Forge of Freedom. Today, I've got it's a Second Amendment related topic, but it's not really just about the Second Amendment, and it's actually not even primarily about the Second Amendment. It's more about the Supremacy Clause, and the basis of our discussion today is going to be about a recent opinion that was issued by the United States Court of Appeals for the Eighth Circuit, and it was issued last week. I think it was August 26th, and I'll put the decision up here on the screen here momentarily for those of you watching by video. But the decision, it was with respect to the Missouri so-called SAPA, SAPA, which stands for the Second Amendment Preservation Act. And for those of you who have followed the podcast, who maybe even watched some of the podcasts that I did with Paul Lathrop at the Polite Society podcast, we talked about these a number of years ago as they were becoming popular. Various states adopted these. They were basically Second Amendment sanctuary laws, which were sort of analogous to the immigration sanctuaries, so-called sanctuaries. But these Second Amendment Preservation Acts, or Second Amendment sanctuary laws, were adopted to essentially prevent state and local officials from assisting or helping federal agents in the enforcement of federal gun laws. Because the state basically said that these federal laws, in our view, are unconstitutional, and we don't want to expend state or local resources in the enforcement of unconstitutional resources. They felt like it's our obligation to protect the citizens of our state from unconstitutional and tyrannical acts by the federal government. So anyway, Missouri adopted one of these laws back in 2021, which was of course early on in the Joe Biden presidency. And there was lots of talk about what sorts of gun control measures that Joe Biden and the Department of Justice might pursue. And of course, there were rulemaking actions taken by the ATF with respect to bump stocks and short barrel rifles and what it means to be engaged in the business and all sorts of unconstitutional, in my view, federal gun control measures. And there was this big push. Well, there was this equal and opposite reaction, right, from the states in the form of these Second Amendment Preservation Acts. And so I'm going to get into this decision by the Eighth Circuit here momentarily. But for a little bit of background first, number one, I'm going to put up a map here just so you know what we're talking about. And this is a map of federal circuit courts so that you have an idea what we're talking about here. This opinion, this decision that we're getting ready to talk about is out of the Eighth Circuit. So, of course, Missouri adopted the law. Missouri is within the Eighth Circuit Court of Appeals. And so this decision, after it was addressed, after the issue was addressed by the trial court, by the district court in Missouri, it was appealed, and it was appealed to the intermediate court, the Eighth Circuit Court of Appeals. Now, of course, it could be appealed once more to the United States Supreme Court. And this is a case that's in federal court rather than state court, obviously, because the United States federal government has sued the state of Missouri and asked the federal court to enjoin, that is, to prevent Missouri from implementing this law. So that's what we're talking about here. It's a challenge to a state law by the federal government, particularly the Department of Justice. But basically what they're saying is that Missouri, by adopting this law, and part of the law says that they believe the certain federal gun control measures are invalid or unconstitutional. So the federal government has come in and said, they can't declare a federal statute to be unconstitutional. They don't have the authority to do that. And courts, we want you to invalidate this law. So we're going to break that down here just a little bit. And this really touches on, like I said earlier, this is not primarily a Second Amendment case, even though it has huge implications for the Second Amendment. It's primarily about what powers the states have with respect to the federal government, vis-a-vis the federal government, and what is meant by the Supremacy Clause in the Constitution. So with that in mind, actually, I'm going to bring up the Supremacy Clause. If you go to constitution.congress.gov, there's the full text of the Constitution there at the website. And if you scroll down to, it'd be actually Article 6 that we're going to talk about here. And you have to scroll down a little ways here. And it's paragraph 2, clause 2 of Article 6 of the United States Constitution. It says, "This Constitution and the laws of the United States which shall be made in pursuance thereof." And that's key language here. Made in pursuance thereof. "And all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding." So that's the Supremacy Clause of the United States Constitution. We're going to get into what that means and how that's so widely misapplied and misinterpreted by the courts especially. So let's get into this opinion. This, like I said, this was issued, and this is actually an annotated version. I've highlighted portions of the Eighth Circuit's opinion here. This is issued, you can see here, August 26th, 2024, and it's Circuit Court Judge Colleton. I think I'm saying that correctly, but it is United States of America as the plaintiff versus the state of Missouri. And so what this law does, and you see here at the beginning of the court's opinion, is that it classifies various federal laws regulating firearms as infringements on the right to keep and bear arms guaranteed by the Second Amendment. It says the act declares that these federal laws are invalid to this state and shall not be recognized and shall specifically be rejected by this state. So this statute, like I said, adopted in 2021 in its Missouri statute, you can see the section number 1.410 to 1.485, states that a number of these federal statutes are invalid. And you can see they're listed here 1 through 5 in the court's opinion. It talks about taxes levied on firearms accessories, or ammunitions, anything that might be reasonably expected to create a chilling effect on the purchase or ownership of those items by law-abiding citizens, any registration or tracking of firearms accessories, or ammunition, any registration or tracking of the ownership of firearms accessories, or ammunition, any act forbidding the possession, ownership, use, or transfer of a firearm accessory, or ammunition by law-abiding citizens, and fifth, any act ordering the confiscation of firearms accessories, or ammunition from law-abiding citizens. As you can see, I think these sound perfectly legitimate. The federal government shouldn't be able to do any of these things, but they do these things, and they try to do some of these things on a regular basis. And especially, like I said, over the past few years, the Biden administration through the Department of Justice has been acting more aggressively to implement, especially rules through the ATF, to confiscate things like short barrel rifles, or firearms equipped with pistol stabilizing braces. Or to make private transactions that would be subject to an FFL requirement, what it means to be engaged in the business, for example. So there are all sorts of, those are just a couple of examples. There were all sorts of efforts and measures that the federal government was taking to try to infringe on the right to keep and bear arms. So Missouri implemented this law, and the law basically said that the agents of our state cannot assist the federal government in effectuating any of these 5 things that we've listed, because we believe these to be infringements on the right to keep and bear arms. And there's actually some punishment for violation of this law. So it says each violation of the act is punishable by a $50,000 penalty. And prevailing parties, other than the state of Missouri, so if an individual sued a state agent, they may recover attorney fees and costs. So this law made it easier for people to vindicate their rights through the law, because they could get their attorney fees paid for. You don't have to front the expense of an attorney for a violation of this statute. But this statute is not primarily about declaring federal law unconstitutional, right? It's about refusing assistance in the enforcement of those laws. So the state is saying, here's the reason why we're implementing this law, but what the law actually does, the operative part of it, is that it refuses state assistance in the enforcement of it. And actually the court here, the Eighth Circuit, says the state of Missouri is completely within their right, their power to do that, to withhold assistance from the federal government in enforcement of their own of federal laws. That touches on a long-standing doctrine called the anti-commandeering doctrine, which says that the states cannot be forced, they can't be co-opted by the federal government to assist in the enforcement of federal laws. And this is problematic because the federal government doesn't have the manpower to enforce their own laws. They have something like somewhere between 2,500 and 4,000 ATF agents, and a number of those are administrative, only serve an administrative function. So for them to go out and enforce all of the federal gun control laws would be nearly impossible. And believe me, that's far too many ATF agents. But nevertheless, it's not enough to enforce effectively all of the federal gun control measures. So they have to rely on state law enforcement and state officials to help assist with the implementation and enforcement of federal laws. And so this law in Missouri was effective at withholding assistance from the federal government in the enforcement of federal gun control measures. And at the trial court level, you'll see here in the appellate decision that on the merits, the district court, the trial court, ruled that the act, the Second Amendment Preservation Act, violates the Supremacy Clause not because it withholds assistance from the federal government, but because it purports to invalidate federal law. And of course, this law, the state of Missouri cannot invalidate federal law, but you notice the language they use, it purports to invalidate federal law. And so that's because the state of Missouri is perfectly within its power to withhold assistance from the federal government. That can't be the basis to declare this statute, the Second Amendment Preservation Act, invalid or unconstitutional in violation of the Supremacy Clause. But they say, and they find some wiggle room in the statute because it purports to invalidate federal law, which, remember, it wasn't invalidating any federal law. They're saying, because we believe the law to be unconstitutional, we are going to withhold assistance. Their belief that it's unconstitutional is not saying we declare it to be unconstitutional. It is unconstitutional. It is invalid. It doesn't have any constitutional effect on the law, the federal law. All it's doing is saying, here's the reason why we're doing it. And this is what we're doing. We're withholding assistance. Nevertheless, the court here, the district court and the appellate court say, because it purports to invalidate the law, we're going to enjoin the state of Missouri from carrying out the entirety of the Second Amendment Preservation Act. And they go through this discussion about whether or not the United States has standing to bring the lawsuit, whether or not they were harmed by Missouri's law. And here's the important part. After the court goes through its standing analysis and says the United States has standing for all of these reasons, they say, and this is really interesting here. This is started on page 8 out of 10 of the court's decision. They say the Supremacy Clause states that federal law is the supreme law of the land, and they put it in ellipses, ... anything in the Constitution or laws of any state to the contrary, notwithstanding. The thing is that ... that they put in there leaves out the most important part of the Supremacy Clause. So let's go back to the Constitution here. Remember, when we read at the beginning of this episode, Article 6, Clause 2, Paragraph 2 of Article 6, this Constitution and the laws of the United States. Now let's go back to the opinion. The supreme law of the land, ... This Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land. So they left out, in their opinion, this most important part. The Constitution and the laws of the United States, which shall be made in pursuance thereof. So for the federal law to be supreme, the laws have to be made in pursuance thereof. In pursuance of what? The Constitution, right? This Constitution and the laws of the United States, which shall be made in pursuance thereof. And so just because federal law says something different than state law, it doesn't automatically supersede state law unless it's in pursuance of the Constitution. And let's go a step further. Not only does it not supersede state law, it's invalid, it's null, it's void if it is not in pursuance of the Constitution. And that's what the court here in their decision leaves entirely out. They don't even, they say, the Supremacy Clause states, as if they're repeating the entirety of the Supremacy Clause in whole here, states that the federal law is the supreme law of the land. And that's not what it says at all. It only says that if the law is made in pursuance of the Constitution. So they do go on and say anything in the Constitution or laws of any state to the contrary, notwithstanding. But they leave out the most important part, of course. So that's the entire basis, essentially, of the enjoyment of Missouri's Second Amendment Preservation Act, is that it's in violation of the Supremacy Clause. And so this decision, I think, by the Eighth Circuit is wrong for all sorts of reasons. Number one is the logical problem. They're saying that it purports to invalidate federal law, so therefore it's unconstitutional. They were just trying to find a reason to invalidate this Missouri Second Amendment Preservation Act. And they found that little bit of wiggle room to justify their, although tenuously, justify their decision. Because remember, what this law does operatively is withhold assistance from the federal government. That's it. And then provide a penalty, actually. I shouldn't say that's it. It also provides a penalty for people who violate the statute. But essentially what it does is it prevents state officials from assisting in the enforcement of federal gun control measures. So it's a short opinion. Of course, I'll link to the Eighth Circuit's decision here in the show notes. Go read it for yourself if you're interested, especially in the standing issue. I don't think, frankly, that's the most interesting part of the discussion. It's really, it's not surprising anymore. But early on in my law school years and maybe in my first few years as an attorney, it was always a bit surprising to me the lengths to which federal courts, especially federal circuit courts and even the Supreme Court on many occasions, goes to find in favor of the government, especially the United States government. And that's what they did here. So this is a little bit of a setback. The good news is I think there's something to learn here by other states and by Missouri, that I think that these Second Amendment Preservation Acts will be upheld as long as they don't purport to invalidate federal law. So as long as they don't say that the federal gun control measures are invalid or unconstitutional, I think that these Second Amendment Preservation Acts will be upheld. And frankly, why am I talking about this? Because I think this is important for the preservation of individual liberty going forward. We cannot, and I've said this numerous times before, we cannot rely on 9 black robes at the Supreme Court to protect our individual liberty. Yeah, it's nice when they make decisions like Bruin, when they make decisions like Heller, that create sort of a bit of a bulwark against infringement, at least for some period of time. But what if Kamala Harris is president? What if she wins the election and she has an opportunity to nominate 1 or 2 justices to the United States Supreme Court? The balance flips entirely. And it's not beyond the realm of possibility that some Supreme Court in the future, the not too distant future, could say that basically the Second Amendment doesn't provide any protection of individual liberty. They could undo Heller, they could undo Bruin. This is not some fairy tale end. This is a real possibility. And so our rights should not be predicated on the composition of the United States Supreme Court. And we shouldn't rely on the United States Supreme Court to protect those rights, whether it's the Second Amendment or any number of other liberties that we have and still enjoy. The path to liberty is paved with actions like this out of Missouri, with nullification of unconstitutional federal government action. Our liberty is protected most effectively at the state and local level. And that's why it's so important to be engaged more so in the preservation of liberty at the state and local level than it is at the federal level. Because I think at the federal level, there are things that we can do to sort of stymie the imposition of liberty going forward, or imposition on liberty going forward. But I think that the bastion of freedom is at home. It's in your state, it's in your city, it's in your county. And this example out of Missouri, I think, gives us great hope that that states can and will act to nullify many unconstitutional and tyrannical federal actions going forward. There were other states, of course, who implemented similar, though not identical, laws to Missouri, and I hope that other states join in this movement because, like I said, we can't rely on the federal government. The federal government, I think, is mostly a lost cause. Long term, short term, I think that there are great things that we can do. But in the meantime, we need to get our act together locally so that we're in a position to nullify and make the federal government ineffective when it becomes even more tyrannical. All right. I want to point you to a few other resources here before we close up the show. The first is an article by Ilya Soman over at Reason magazine. He writes for the Volokh conspiracy. He's got a great article about this subject. I would point you to that and encourage you to go read that as well. Actually, I'll put that up here on the screen just so you know what I'm talking about. The article is called Eighth Circuit Wrongly Struck Down Missouri's Gun Sanctuary Law, but also created a roadmap for how such laws can escape invalidation in the future. I would also point you to the 10th Amendment Center. They've got some great resources about how we can utilize the 10th Amendment to protect the Second Amendment and other individual rights. They've also talked a lot about the Supremacy Clause. They talked about it at length over there on their website and on their podcast. So be sure to check out the 10th Amendment Center if you're not familiar with their work. Michael Bolden also did a video about this very subject, the Missouri Second Amendment Preservation Act. So be sure to go check that out as well. It's in their Path to Liberty podcast. So I'll put that up here on the screen at Twitter. It's also on YouTube and various other channels as well. So definitely go check out the work that and the great work that the 10th Amendment Center is doing. All right, everybody, I hope you learned a little something there. Like I said, I'll link to all these resources in the show notes. You can find the show notes, as always, in whole, the complete show notes at forgeoffreedom.com, where I link to every episode. You can also find the episodes on, as always, at YouTube, Rumble, Facebook, and you can follow me on X at Forge of Freedom. I'm going to have a special guest next week, Yehuda Reamer. He's also known as the Pew Pew Jew. He wrote a book on gun safety. He's also a well-known Second Amendment advocate. I look forward to having a conversation with him about his book targeted toward children, about how to be safe when you're around firearms. And so please stay tuned for that. Be sure to check that out next week. That'll be, of course, episode 151. All right, everybody, thanks for tuning in. I'd like to ask you a favor. If you would, if you're listening on Apple Podcasts or Spotify or YouTube, especially Apple Podcasts or Spotify, please leave a review. Give us a rating. That helps us get shown to put our content shown to more people like you who might have an interest in the sort of work that we're doing here. It's a coincidence. I can't prove this, but in the episode that I did a few weeks ago, criticizing the Bloomberg group, the Trace, as soon as I responded to their request for clarification, I immediately got a couple of bad reviews. So I suspect that their content editors immediately went and left 1-star reviews. So it's possible it was somebody else. But it was just coincidental that it was the same day that that episode came out. So please go help me bolster the review number on Apple Podcasts and Spotify. And as always, if you can like our episodes on YouTube and Rumble and Facebook, that helps us as well. So thanks again, everybody, for tuning in. And until next time, remember, you are the Forge of Freedom.